Hi guys, my name is Kyla Marquardt, and I just wanted to hop on the internet and share this moment in history about the Santa Clara County versus Southern Pacific Railroad Company. Now, I just want to share with you guys some facts and interest you on the several rights about this and explain to you what the importance is and what happened, basically. So, the case arose when several railroads refused to allow California state law that gave less favorable tax treatment to some assets owned by corporations as compared to assets owned by individuals. The Associate Justice John Marshall Harlan's major opinion held for the railroads, but his opinion did not address the Equal Protection Clause. However, a head note written by the court reporter and approved by the Chief Justice Morrison Waite stated that the Supreme Court justices unanimously believed that his Equal Protection Clause did grant constitutional protections to corporations. The corporations, as well as natural persons, although the court's opinion in earlier cases such as Dartmouth College versus Woodward had to recognize that the corporations were entitled to some protections of the Constitution. The facts about this are that at the California Constitutional Convention of 1887 to 1889, a state legislator drew up a new constitution that denied railroads the right to deduct the amount of their debts from taxable values of their property, a right which was given to individuals. Refused to pay taxes under the new changes. The tax-paying railroads challenged this law based on the conflicting federal statute of 1866, which gave them privileges inconsistent with state taxation. The county of San Mateo, along with neighboring communities, filed suit against the railroads that recouped the massive losses in tax revenue stemming from Southern Pacific's refusal to pay. After hearing arguments in San Mateo County versus Southern Pacific Railroad Company, the California Supreme Court sided with the county. So the Supreme Court of the United States issued a opinion consolidating three separate cases: the Santa Clara County versus Southern Pacific Railroad Company, California versus the Central Pacific Railroad Company, and California versus Southern Pacific Railroad Company. So the head note, which was mentioned earlier, which was not the work of the court, but is simply the work of the reporter giving his understanding of the decision prepared for his convenience of the profession, was written by the court reporter and former president of the Newburgh and New York Railway Company. And he stated, one of the points made and discussed at length in the brief of counsel for defendants in error was that corporations are persons within the meaning of the 14th Amendment to the Constitution of the United States. Before argument, Mr. Chief Waite said the court does not wish to hear argument or question whether the provision of the 14th Amendment to the Constitution, which forbids a state to deny any persons within its jurisdiction to equal protection of the laws, which applies to their corporations, where all their opinion that it does. So the head note was reporting by the court reporter of the Chief Justice's interpretation of the justice's opinion, but the issue of applicability of equal protection to any persons the railroad was not addressed, and decision of the court was in case. Their argument, while the decision of the court did not rest on the 14th Amendment, an argument on this ground had begun delivered by the defense. Basically explains that the provisions of the Constitution and laws of California in respect to assets of for taxation for the property of railroad corporations operating railroads in more than one county. So the judgment basically ends up saying that the argument in behalf of the defendant is that the state knowingly and designedly included its assessment for the franchise railroad, roadbed, rails, road stalking of each company, the value of the fences, basically saying that they can tax them. And yeah, so thank you guys for listening, and I really appreciate it.